नमस्कार दोस्तों, आप सभी का स्वागत है एलएलए के 18th वेबिनार में। और आज हम बात करने वाले हैं कोड ऑन इंडस्ट्रियल रिलेशंस के ऊपर। और आज के जो हमारे स्पीकर हैं, ही इज वन ऑफ द वेरी वेल नोन प्रैक्टिशनर इन दिस फील्ड। आपका नाम है अमीर सिंह पेशरिच। He is a commercial lawyer with wide range of experience in continuous and non-continuous work and has practiced in India since 1992. He is now primarily involved with commercial disputes and arbitration. He acts as counsel to the law firm that he has founded. He has been involved with international and cross border work, having chaired the International Sales Committee of International Bar Association IBA. He is a he is now a member of IBA's Legal Practice Division Council. He has been recognized individually by Legal 500 and Chambers as also Who's Who Legal in multiple disciplines. As a counsel and advocate, he has several reported judgment to his credit and has spoken at several dozens international conferences as well. He has been chairman of Law and Justice Committee of the PhD Chamber of Commerce and Industry and is presently also vice president of Oxford and Cambridge Society of India. तो आपने क्रेडेंशियल्स सुन ही लिए हैं। और जैसा कि आप जानते हैं, कोड ऑन इंडस्ट्रियल रिलेशन इज वन ऑफ द मोस्ट इंपॉर्टेंट लेबर कोड्स, और इसमें काफी सारे ऐसे बदलाव हुए हैं जो ओवरऑल आने वाले समय में ना सिर्फ एम्प्लॉइज को बल्कि एम्प्लॉयर्स को, एचआर को, सभी को इफेक्ट करने वाले हैं। आपको जैसा पता होगा, इसमें तीन एक्ट्स को अमेलगमेट किया गया है, विच इज इंडस्ट्रियल डिस्प्यूट एक्ट, इंडस्ट्रियल एम्प्लॉयमेंट स्टैंडिंग ऑर्डर एक्ट एंड ट्रेड यूनियन एक्ट। तो ज्यादा समय नहीं लेते हुए मैं इनवाइट करना चाहता हूं सर को, अमीर सर को। सो वेलकम सर, वेलकम टू लेबर लॉ एडवाइजर। Sir, your mic is muted. Yes.
Can you see? Good afternoon or good evening. Hello. Okay, I'm sorry about the technical problem, and I hope you didn't overhear me complaining about PowerPoint. I hope you can see it. There's a PowerPoint on my screen. Is it
Yes,
possible
we can
for
see
you
it, sir. Yes, we can see it, sir.
Is it clear? Oh, very good. Excellent. Now, if I look to the left, it's not because I don't like you. It's because I'm looking at a bigger screen on the left. So that's mystery solved today.
Okay, sir.
Now, let me just explain what's happening here. We are going to talk about what is called the Industrial Relations Code, which was enacted as applicable law in 2020, but is not yet in force. Now I have to work out how to move this PowerPoint. How do you move this? Oh, yes, it's all. Yes, good. It's all working. It's all working. It's all good news. Very good. So we have the origins of this code going back to 1999. And that shows you how fast India works. In just 21 years, it has come up with a new industrial code, which perhaps was needed. But we have a lot of questions asked as to why it has been enacted, what is the purpose, and I'm sure you'll see that there's a certain rationalization. I'm very positive on that rationalization on one front, because in this journey of examining this law so far, I have not seen radical change. There's no hidden agenda apparent. There is certainly change. And from my point of view, it's for the better. Some people may consider certain moves to be quite radical insofar as an industry from 100 is now under-regulated up to 300. So those are changes that you'll see as we go through this journey. Let me explain what has happened so far. If you look at the screen, you'll find 4 labor codes. There's a code on wages that came into force in 2019, and even the rules have come out, and there are significant changes in the code of wages which involve overriding the old Payment of Wages Act, the Minimum Wages Act, Payment of Bonus Act, Equal Remuneration Act, all of those consolidated together. Then we have the Occupational Safety, Health and Working Conditions Code, which we need an acronym for. It's very long. But if you were to find out how many acts this replaces, you wouldn't mind its length. It covers the Factories Act, Mines Act, Dock Workers, Building and Other Construction, Plantation, Contract Labor Regulation and Abolition. I'm going to pause here for a second. The Contract Labor Regulation and Abolition Act changes, and I have quite carefully studied them, in that act have involved a move from what used to be 20 plus to 50 plus. So what you're going to see is, to some extent, we can call it deregulation. To some extent, you can call it an opening up. But under that Occupational Safety Act, when you look at it in conjunction with the Contract Labor Regulation and Abolition Act of 1970, you must understand the changes that are being made are quite significant in the light of resistance that you'll always have from a lot of interests from different sides. And they're not vested interests, they're just different interests. So in the Contract Labor Act, the old act as it used to be, you had something called Contract Labor Regulation and Abolition. The abolition has slowly disappeared. That's an important understanding of change of law, because now we are concerned and accepting of the whole ethos of contract labor. We're willing to bring them in from outside and not abolish contract labor for the sake of regular employment, which I'm going to speak to you about for a second before going further, because this is basically it's a in principle change. If you think about it and you go back to 1947 and then the Contract Labor Act of the 70s, it was an avowed purpose of the government to avoid contract labor as far as possible. And it is still there. There are still some interesting provisions which you'll find in the labor code, which I call vestigial. Vestigial means they are sort of useless, less used, or they will fall into disuse, but they still exist. For example, it says in the unfair labor practices that it is still an unfair labor practice to employ workmen as badlis, casuals, temporaries, and continue them as such for years with the object of depriving them of the privileges of permanent workmen. Notwithstanding this problem, I mean, if that is an unfair labor practice even today under the new labor code, despite it still being an unfair labor practice, you have a recognition now coming up, and you'll see it today, and therefore please make note, pay strong attention to the fact that unfair labor practices notwithstanding, we recognize fixed term employment for the first time as a separate class in the new code, the Industrial Relations Code, and that is what I'm going to be talking about today. Yeah. If you look further down on this slide, you'll see that there has been a rationalization where the government has adopted the recommendations of the Commission, consolidating so many state laws and 40 central laws across India. So the effect of that has included under for example, the Occupational Safety, Health and Working Conditions Code, a whole series of motor transport workers, journalists, interstate migrant workmen, all that has come under one law, and this is what it looks like. Coming to the Industrial Relations Code, I should mention that the code will be is likely to be notified by the beginning of April, and I'm told that it may even come into force in February or March. So we have you have to watch this space carefully. There is change in the offing, and here it is in the next few slides. Now it's not working. Just a second. Here we are. Good. So these are the new codes. I've just talked about them. We can skip to the next slide, and you'll see what do they hope to achieve. This is very important to understand, because if you don't understand this, there are many times where people are looking for diamonds and gold when they need to look for the basics, and these are the basics. So the government's avowed objective is simplify and consolidate. Fine. Actually, that was needed because some of these laws were growing into the Income Tax Act type of provision, where you had subclause A, B, C, D, and ZA and ZB and ZC. So we brought them together. That's good. Making it simpler to read and understand. And workers and workmen and employees all now need to understand laws in a better way so they can pick them up themselves. And you don't need to go to lawyers all the time. You can read them in a more simplified manner. Now, that's the same with objective number 2, uniform definitions. We had a very interesting set of provisions where if you didn't have a lawyer around, you couldn't understand it. You had to go to 3 different laws to understand what is the effect of a definition. You might have cross references between 2 laws. That is reduced. The number of authorities is reduced, and therefore there's less conflict. And I'd like to point out that from my experience and knowledge, and I'm not here today to speak about case law, but from my experience and knowledge, if you go through the labor case law, you will see a tremendous amount of court interference over these 70 years because there was so much confusion arising about what was the purpose of the law. Now, this is, I think, a lot clearer. So there's transparency and accountability, and that's an interesting word, transparency, accountability. When we get to the sections on penalties, I can refer you to some of them and show you how the government has tried to make it less likely to be subject to the Inspector Raj. I think those are laudable changes, and that is the best part of this law, insofar as it may be that over the next few years, we don't have to run from the inspector who arrives unannounced at every industrial establishment and says, I've come for an inspection, look after me. Not quite going to happen in the same way now. So that is one of the things that is reduced, and they say so. And lastly, the ease of doing business, EODB. I am personally one of the authors or the contributors to the World Bank Doing Business report, which comes out for the last 7-8 years. And we have specific questions on what is the ease of doing business when it comes to dispute with a laborer. How long will it take? I think the worst thing about India and the kalank on us and our legal system is the fact that we have so much time spent in litigation. All these books and these laws are useless if their effectiveness is curbed by delay. And that is one of our biggest problems. This law, I think, helps because you're not going to be prosecuted so fast. There'll be a system, a fine, you'll pay the fine and move on. And I hope that in reading that effect of those penalties also, especially, there won't be so much threat to the employer that he fears the law, certainly, but at the same time, his life is not destroyed because he's got an industrial dispute hanging over his head with an automatic stay. He cannot change the conditions of service. He cannot come to an arrangement. Those are things that have to be played out. And I can't promise you that these new codes will do that, but they are beginning to go in that direction. Now, here we have what the Industrial Relations Code replaces, and it's fairly basic. You can see it on the cover of the Industrial Relations Code. Here it is. It is replacing the Trade Unions Act. Why do I want to talk about the Trade Unions Act? The Trade Unions Act is an act for recognition of trade unions and regulation. And at that time in 1926, with its changes since then, the act, I don't think, was integrated with Indian labor law. And to that extent, now it is. It's much better. The Standing Orders Act is also a 1946 act. It has been changed to some extent. It operated with a number called 100 employees or more. So that threshold has now gone up to 300, and that's a uniform 300. The Industrial Disputes Act had two thresholds earlier in chapters 5A and 5B. Chapter 5A applied to 50 or less, and then chapter 5B applied, 50 or more, and chapter 5B applied to 100 or more. So now that has changed. We now have 50 or more up to 300. And so the minimum standard of what used to be chapter 5A of the Industrial Disputes Act has been shifted and the threshold gone up. You have less regulation. You still have regulation, but you don't have, Big Brother watching you, permissions and approvals to that extent necessary for conducting your business until you hit at least 300 employees. And therefore, Chapter 5B, as it now stands under the Industrial Relations Code of 2020, is effectively somewhat diluted, but quite a lot in force for 300 and plus. So between 50 and 300, the freedoms have grown. You are entitled to terminate an employee, retrench an employee without running to the government and begging for permission or hoping that they'll not notice your application so that automatic permission comes. You don't have to go running to them for a closure of an establishment under Section 25O, which used to be the old law if you had 100 employees, which was a little bit onerous because 100 is not a very big number. Most of our MSMEs run at the level of between 100 and 200. So 300 certainly brings us into the industrial level where we are where we are secure in the thought that they require regulation, they require protection. There's a very large number of people involved, and you can't leave it to just the forces of contract. Why do we still have that regulation? That's anyone's guess. I think largely we're not breaking down the mechanism of regulatory systems and norms, and checks and balances. We are lifting some of those checks and balances to free up the economy for freedom of contract, less approvals, less inspectorage, and less litigation, which is part of the experience of the last 70 years has been there is just too much regulation for small businesses. And the consequences, they just ignore it. They burrow under, they disappear, they multiply. One husband will employ 50 and the wife will employ 50. That's not the way around now. So it's much better to have a bigger limit than to encourage people to dodge the limits. So these are the norms, and this is how the Act purports to do it. These are what it says it will go out to do. Now, if we look at this is IRC, just for your knowledge, if you haven't noticed above, is the Industrial Relations Code. And where is it changing things? It is changing things quite dramatically by the definition of worker, which was previously known as a workman under the Industrial Disputes Act. We have got some new language coming out, which it changes matters because the disputes that used to arise about particularly employers, saying, no, but he's not a workman. The limited definition of workman doesn't cover him. So you went up to the Supreme Court to determine whether he was a workman or not. And then you came back to the Industrial Tribunal because the matter was remanded by the Supreme Court after deciding, oh, that is a workman. Could be a pilot, it could be an air hostess, it could be, certain types of workers. So those definitions have become a little easier to effect. And there's also a bifurcation. I don't know its effect, so don't ask me for details on this yet, because even I have to see how it pans out. And I have to give you a disclaimer here. As a lawyer, I have to say that, in the case of the Industrial Disputes Act, we've had my first labor dispute was in 1992, the year that I joined the profession. After 28 or 29 years of practice, I certainly know a lot about how that law functions. But I can't say the same about the Industrial Relations Code. For me, it's pure theory right now. We have to see that in effect, and you can't hold a lawyer to the consequences of a new law till it's been effected. And that's going to take another 5-6 years. When the new law comes into force, new definitions are considered, and the new definition of worker is one of them. So let's look at that definition and understand what's going on here. I do want to take you into some depth, so forgive me if I'm somewhat pedantic. I like to show my audiences legal provisions. This is one of them. It includes a person in a supervisory capacity. So you had a lot of people being called supervisors and managers and designated as, customer service supervisor and customer service whatever, so that they would not be regarded as workmen. And then if they went in a dispute where any common sense would tell you this person should be entitled to raise a dispute against his employer, whether he's entitled to the relief is a separate issue. But this, this gateway of workmen should not come in the way. That, I think, has been slowly washed out by the new definition. And at least up to 18,000 rupees, which can be changed by notification and not by statutory amendment. The person working for an organization would be regarded as a workman, no matter how you designate him. This definition doesn't mean that a workman earning more than 18,000 is not a workman. We call them workers now. It means that you have a minimum criterion of 18,000 for a supervisor to escape the definition. Now, I don't like that per se, because it's still possible to pay someone 19,000, call him a supervisor, and then not designate him as a worker. So you might have solved some of the problem. You've not solved all of the problem. Sorry. Now, come down to the definition of employee. And you ask, why do we need a separate definition of employee? That's because as we work our way through the Act, the new code, you will find that the use of the word employee allows certain rights to be arrogated to an employee. He can raise an industrial dispute. He can take you through, he can claim certain privileges, and he is, the word employee subsumes the word worker in it. So those are things that you're going to see a slow transition of rights and privileges, because now you've got two categories, and the idea is to enable, not to disable. Now, the word employer has also changed. Why does it matter? Well, because these underlined words here on your screen, whether directly or through any person, or on his behalf or on behalf of any person, one or more employee or worker in his establishment becomes an employer, right? So it is now difficult for an employer to shy away through indirect employment from the definition. And if you remember, the word principal employer coming from the Contract Labor Act will get subsumed within indirect employment. So this is also something that will slowly pan out. Now look carefully at the dashes on the left. Person who employs directly or through another person, or on his behalf, or on behalf, fine. Then or in relation to an establishment which is a factory, the occupier, or in relation to any other establishment, the person who has authority and ultimate control, or the contractor and legal representative even of a deceased employer. That didn't exist earlier. I must thank you for making it bigger for me to read. Okay. So we're in a position where we are widening terms and we are getting rid of the muck. This makes it possible to move also now to a definition of the word industry. This is widened. Cooperation between an employer and worker, whether such worker is employed by such employer directly or through agency, including a contractor. Now, I've used the word CF is for comparison. The IDA employer, which as it used to be was considerably limited. Now look at the bottom of that. You'll see the words whether or not any capital has been invested for the purpose of carrying on such activity. How does that work? But that's a very interesting question. The first disclaimer is I don't know. But my gut feeling is whether or not any capital has been invested would cover voluntary organizations, cooperative societies, people like that who employ large numbers of people. So we have to see how this new provision pans out. And whether, I mean, if you look further down, there are a whole series of exemptions. And the government can notify certain activities that are not falling within industry. For example, you'd say, does a diplomatic entity fall within industry? Well, obviously not. But it has to be notified or it has to be recognized. And that's a matter of some time. This will take time. Now look at the recognition of fixed term employment, which is newly emerged. If you remember, for those of you who know some of this law well, under the Industrial Disputes Act, you had something called Section 200B of the Industrial Disputes Act. What did that section do? Let me just give you a refresher on what it did. For those of you who don't know these famous subsections and subnames by heart, Section 200BB of the ID Act 1947 said that it is not retrenchment to fire somebody, not to fire him, but to conclude his contract at the end of a fixed term and not to renew it. That definition was used tremendously by industries. And here's where I underline the fact that there is a disconnect between the definition in Section 200BB and the avowed purpose of unfair labor practices, which I read you earlier about employing people and continuing them for years without making them permanent. If you remember, I read you that earlier. It said to abolish the work of regular nature and to give such work to contractors that as a means of breaking a strike, yes. And secondly, sorry, I was looking at the wrong one, to employ workmen as badlis, casuals or temporaries. So what is a temporary under the unfair labor contract terms? Is a fixed term employee not a temporary? Could he be a temporary if he's 1 year fixed term? And to continue them as such for years That's also happening with the object of depriving them of the status and privileges of permanent workmen. That is the unfair labor practice. Now come back to 200BB of the old Act, and you will find that it excluded termination of the service of a workman as the result of non-renewal of his contract. So you didn't have to pay him retrenchment benefit. At the time of termination, what was retrenchment benefit? 15 days pay for every completed year of service under section 25F, and 15 days pay for, yes, and 30 days notice, and one other. There were three. So that benefit, which was not payable for a fixed term employee, has still remained in the new Act, in the new code. And I ask myself the question as to why we are continuing this system by which it is still an unfair labor practice, but we recognize fixed term employees and we allow this to happen in this rather strange way. I'll explain why. In the case of Kishore Chand Samal, which is a Supreme Court judgment of around 2007, I think, it was a stenographer who had been employed for some 17 or 20 years, many years, under contracts that were 15 days and 45 days, and they kept being extended for fixed term. And the Supreme Court was bound by the law, and they said, well, it's a fixed term employee, he's not entitled to regularization. Now, that has not changed. And so, if we look back at my PowerPoint, thank you, Rishabh, if you could. Now, if you look back at my PowerPoint, you've got section 2O of the code, which is that there's a new balance coming out now. That's a slight improvement, which is that they are now entitled to ESI, EPF bonus, and wages at par with regular employees. Now, these are very important changes because at least you found some balance here. Employee stock, employee state insurance, employees provident fund, bonus, and wages. All of that was being excluded by contract. Now it will be payable as long as he completes at least 1 year, and there'll be some places where he may not get it by contract, he may waive it or whatever, but the entitlement is there in the law now. And the second point here, it's very important to understand, is gratuity. Now this is a very strange provision. You cross 1 year, you're entitled to gratuity as a fixed term employee, but if you get a permanent contract, long term, say you get a job with someone and he hires you for 2 years and then fires you, you're not entitled to gratuity because you haven't crossed the 5-year threshold of gratuity, which is required under the Gratuity Act and now adopted under the under the Social Code on Social Security, which you will find this one. This code, the Code on Social Security, picks up the Gratuity Act and plugs it in with the same 5-year requirement. But if you're a fixed term employee under the Industrial Disputes Act, you're entitled to gratuity provided you cross 1 year. So there's a slight disconnect there, but it's not bad. It improves 200BB. It gives them something. It gives them gratuity if they've crossed 1 year. It gives them ESI, EPF, bonus, wages. So we're doing, I think, better than before. Now, Rishabh, could you make that bigger for me in my,
Yes, sir.
my limited eyesight? Otherwise, I'll have to put on my glasses and look very stupid.
No.
Thank you. So we have the old definition of wages. Look on the left. Basic pay, dearness allowance, retaining allowance. Okay. What has changed and why has the new act brought about a new definition? New Act covers A to K, okay, in the definition of wages. And it makes special provisions in proviso number 1, whereby it says A to I, all those things, value of house, accommodation, contribution to PF, conveyance allowance, sums towards, A to I, if you add them up, they cannot cross 50% of the remuneration paid to the employee. Because if they do, then the employer has to do a top up. Now, very interesting. Why is this being done? It's being done for 2 reasons. It's being done because of the parity with the Minimum Wages Act. If you want to call it wages and you have to cross something, the definitions of wages have to be clarified in terms of what is the components of the wages which will go to each for each calculation. How will we work out what is basic, what is bonus, what is HRA? And I think it's a laudable provision because it promotes transparency on the part of the employer. The breakups which were done and salary slips signed by the employee must now be fixed not beyond 50%. So it has a purpose. And there's a safeguard also that if it crosses 50%, the employer has to top it up if they go to an industrial court. The second proviso is also interesting. You'll find clauses, sub-clauses D, F, G, and H over there in bold. Conveyance allowance, HRA, award settlement remuneration, which is rather uncommon, and overtime. There's a provision for equality. So you have to have, I could read it to you, but it'll take a little longer. The second proviso under section 2O, isn't it? 2ZQ, sorry. 2ZQ calls for parity, and that allows the workman a certain another handle where they have to claim equal wages for by gender, regardless of whether it's a man or a woman doing the same kind of work. And how does this matter, and why did they put this proviso in? Well, I can explain to you. There was earlier on an act which called, I don't remember the exact name, but it was Equal Remuneration Act, I think. Equal Pay or Equal Remuneration Act.
Equal remuneration.
Yes, thank you. So this act has been subsumed in this provision, this proviso number 2. So that's a good rationalization, and we have to see how it plays out. Now, if we look at the calculation of wages under this, I've just explained this in this slide, and I perhaps should have done this for myself earlier so I can read it better. It's in bigger print. So we've got, I think I've already covered 50% provision in the first 2 lines. And the second part, what is this 15%? Oh, yes, there's a provision now. This is new. If you give any remuneration in kind as part of the wages, it cannot exceed 15% of the total wages. So again, you're asking for certain basic minimum norms to be set under the law, and money to be paid, not I gave him a bicycle worth 5,000, so I adjusted it from his wages and that kind of thing. This is more transparent, and I think, yes, it'll have cost implications, and this is something that's been highlighted by big industry also, because now each aspect will be, put into their Excel files and brought out accordingly, but the transparency is probably necessary and welcome. Now, I think the most important change, which is what I mentioned earlier, in the Contract Labour Act, we've moved from 20 to 50, and here we're moving from 100 to 300. Major changes and alterations in the way of doing business, in the way of moving from small to medium and medium to large industries, and hiring and firing becomes much easier. So we're looking at a change that effectively allows much more freedom to the employer, but he still has to pay. The minimum standards remain. 25F has been taken in, I don't know it by heart, but 25F has gone to, where has it gone? I'll just tell you in a second. So you don't lose those parachutes, those safety nets, but you certainly have less of the permission process happening. Now, if you look at the expanded definition of industrial dispute, we also have a rationalization here where Section 2A, which made it a deemed dispute between an employee, that is a workman, and the employer, has now become part of the definition of industrial dispute, even between an individual workman, worker. Now it's called a worker. Earlier it was workman. The new definition is worker under the new law. So we have what we call, in George Orwell's language, newspeak. So if we look at disputes relating to the termination of individual workers, we've also, I've noticed this change, which I would like to study better, but frankly, I noticed it today. So I can't promise to give you a big thesis on it or write a PhD thesis on it. There is, if you see the second point of my slide, under the new section 410 and under 53(6), any party may apply to the industrial tribunal for adjudication within 45 days. Now, there's a slight disconnect here, because when you read 53(6), it gives them 90 days to object to the report of the conciliation officer. So is it 45 days included within the 90 days, or how is it to operate? Now, why is this a rationalization? I say it's a rationalization for the reason that the old charade, and I call it a charade, of Section 10 of the Industrial Disputes Act is beginning to be watered out, washed away. That charade meant, and I'm party to that many times, we would go to the conciliation officer and he would conciliate, or so he would do. And we knew that this was going to end up before a tribunal. Then there would be a reference to the government. And then the government, in its wisdom, would decide under Section 10. But the funny thing about the government was it always referred everything it received from the conciliation officer to a tribunal. So why have the Section 10? I think to some extent that process is short-circuited by these two new provisions, 410 and 53(6), by which you can go directly to the tribunal. And I hope that that whole process of referencing and the government's involvement between the conciliation officer and the tribunal dies a natural death, and as soon as possible. Okay, so that's my view on that waste of time, because of one more reason there. Under Section 33, you were under a funny looking stay. You could not move your business around because there's an industrial dispute pending before the conciliation office. It fails, the conciliation fails, and that's not the end of it. You don't know between that twilight zone between the conciliation officer and the government reference and the court going on as to whether or not you can change your conditions of service as an employer. And the employees, of course, took advantage of that, and they don't know whether they'll succeed or not succeed. A lot of this was left to discretion, and disputes went on for years. So the answer has to be that move from a conciliation officer straight to a dispute, decide the dispute within those timelines given in the old Act. You know, there were amazing timelines given in the old Act. Shocking. that none of them were respected. Going back, 28 or 29 years of my life, I failed to understand how adjournments were granted, exceeding the time given for the whole dispute to be decided. And that has happened in my own, experience. Now, I'm going to speed up a bit because I don't think we have unlimited time. I was told about 40, 50 minutes. And so I will bring to your attention a few of the provisions for your knowledge. The Works Committee and the Grievance Redressal Committee existed earlier. They have now been sort of integrated and bipartite forums established under the new code. There's a lovely dispute resolution mechanism process, which Pratik, would you like to? Do you think you could speak a little bit on? If you don't mind, I'm going to ask my colleague
Sure.
to address you for a couple
That
of
would be
minutes.
great. No problem.
There'll be a refresher when my rasping voice will disappear for a while. You'll get a break. Go on, Pratik. Can you hear him? Say hello. I'm going to go on mute.
Just a minute. Yes. I can hear him. Yes.
Hello. Yes. Good evening. So, taking and starting from where Mr. Praseej left off, so we are on dispute resolution mechanism. So, as Mr. Praseej has already mentioned, now they find a place under one chapter, and that chapter is now chapter number 2. That's called the bi-party forums. Now, Works Committee and Grievance Redressal Committee had already found place in the Industrial Dispute Act, but they were placed separately and far apart from each other in the previous or the erstwhile act. Now, the new thing that has also come, or a new provision that has also found place, and this comes due to this IRC code subsuming the Trade Unions Act, and that is the recognition and the framework to give recognition to trade unions. Now, rather than splitting hair on the procedure and the registration and also on the appeals thereof under this act, I'll straight away crack towards how a trade union functions. So, and I'm not also going to speak about the amalgamation because the amalgamation still is covered by this particular chart. So, assuming in an industrial establishment, if there is only one trade union, that becomes the negotiation union as well. The confusion or conflict only arises when there is more than one trade union. So, in case if there is more than one trade union, a trade union which has 51% of the workers on the muster roll, that is the majority of workers, would bypass the other trade union, which of course has 49%, and would become the negotiation union. However, the new concept that gets added, other than of course the negotiation union concept, is the negotiation trade council. So what do you do when neither of the two or more trade unions have less than 51%, do not meet the mark of 51%, and all of them have less than 51%, so none of them have majority? So in those cases, both the unions would come together, and for every 20% of members that they have equivalent to the muster roll, they would get one representative, and the amalgamation of those members together, or a constitution of those members together, would formulate the negotiation trade council. So the single trade union, the sole negotiation union, and the negotiation trade council now finds its way into the dispute resolution mechanism under this act.
I just want to add one more thing. I see a area of dispute, which is that if you have a union that represents more than 10% of the workers, but not even 50, and there is no other union, it could muscle its way in and force the employer to listen to it, even though it's not really representative. And that's something, again, that has to be played out. And we have to see what happens there. I'm going to try and move that slide again. It's stopped. Is it moving? Yes. Okay. Rishabh, how much time do we have? Because I don't want to overdo this.
All up to you. All up to you.
All right, but I'll bore some people to death. What we'll do is we'll try and speed through these provisions just to tell you what's happening. Because if you want to know about what is coming in from the IR code, my purpose is to just bring it to your attention.
Sure,
So
sir.
here is the other provisions of trade unionism, trade union recognition, etc. And these are in sections 27 and is that section 10 of the code? Yes. So we have now effectively subsumed what used to be the Trade Unions Act of 1926. This is what it looked like earlier. Thin little act, not very long, recognizing these trade unions, and we brought its important provisions into this act, and we've integrated them rather well. We've also got a few new things that the government has snuck in, as I call it. They've been slipped in. If you have mass casual leave, then it could be treated as a strike, but I'm not sure it'll be easy to find that because you have to have at least 50% of the workers taking mass casual leave. Then the old provisions for go slow, etc., are still there. However, that some of the timelines have changed, and that's on this slide. So we are effectively slowing down flash strikes. You have to give notice of from 14 days, it's gone to 60 days, and that same provision applies for employers. I have a lovely story going back to the 70s where one of the employers was threatened with action by his employees by some politician, and he ran off to Simla and he locked his factory. And I don't think you could do that now. But on the other side, you can't even threaten a strike at short notice in that way. So there is better regulation, and the involvement of the conciliation officer, etc., would be automatic. And the moment there is the involvement of the authorities, then there's also an automatic stay. So now we're looking at dispute resolution. There is the old provisions are practically unchanged about strikes and lockouts not happening. You will find, strangely, a lot of the language of the Industrial Disputes Act replicated almost exactly in the Industrial Relations Code. So I'm not going to take you there in depth. I want to come to what's happened with the standing orders. The Standing Orders Act kicked in for 100 employees. That threshold is also hit 300 workers. Well, that makes everything far more uniform. It discourages people from having an industry with beyond 299, and that's fine. But it also means that there's a certain number where you will be subject to serious regulation, and I think minimum standards, which perhaps were even needed between 100 and 300, but which are strongly enforced now over 300. So I have a few worries about what would happen to establishments with 100 to 300 workers, now called workers, not workmen, where they don't have the standing orders in line with this. It is possible that those establishments can have a fairly, wide range of freedoms that could trample on some toes of workmen in the next few years. And that also arises because of the use of the word establishment. It means that if I have 10 factories, each factory is a separate establishment. So I might have 299 times 10 employees, but I'm not necessarily subject to the same rules and regulations in each factory. So those things have to play out, and I'll have to see them, how they happen. So this is, my colleague here has done a very nice job of putting together what has happened. Fixed term employment, as I discussed earlier, gives you some additional benefits, and they weren't there earlier. We've already discussed this. Now, this is the definition of industrial dispute widened, and I think he's done a comparative and he's offered that up. Thank you, Prateek. It looks much easier to see here in graphic form. And then we have appeals. The timing has changed. I think earlier it was 30 days against the certifying officer, and now it's 60 days. So there, these things have been inserted. Now this one is a slightly scary provision, which I don't fully approve of in one sense, because there is already a heavy cost on employers at the time of retrenchment. And this one seems to impose a further cost of contributions towards reskilling. So it has to, again, we have to see how it will be effected, but where once it happens, I think that there would be an added cost to employees. Now we are looking at the penal provisions. I actually feel that this is something I could discuss for another 45 minutes. There is so much here in just these few sections. But I would encourage the people on this to read just from sections 85 to 90 to see the changes. Anyone who's a lawyer would find it easy to read. Layman also, it's not difficult. The reason is that where we had penalties, I mean, I'll give you a broad overview of the scheme. Where we had penalties in the form of imprisonment, almost automatic, it was, I've been through a criminal trial involving a general manager who didn't know what hit him when he was summoned for a criminal action involving the Contract Labor Act, in fact, where you can guess why he was summoned. I don't want to give you the reasons in a webinar, but he was summoned. He suffered this criminal proceeding. He was tried like a criminal and eventually exonerated because we were able to prove in the court that they didn't have 20 contract laborers. And in fact, there were contradictions in the case made by the government. But that was lucky. I say it was lucky because, you see, I don't think a general manager of that level who might have 21 contract labor one day and 15 on another should be persecuted by the threat of 6 months imprisonment in these circumstances, not at least for the first offense, which is what had happened in that case. So I strongly believe that the new regime is better. I believe that the penalty system it's much higher. And there was one penalty provision, I can't remember exactly where it is, but in the Industrial Disputes Act, I think it said for all other penalties, 100 rupees. 100 rupees. This is bizarre. But those things have gone. Those are bygones, and you've got 50,000 as the most minimum threshold, and it hits you with 2 lakhs and penalties like that, which perhaps should be imposed, but I don't fully endorse the minimum threshold, which they say that you have to have, if you have a penalty imposed, it has to be at least so much. That should have been left to the adjudicating officer, who is usually a district judge or something like that. So I think that the offences part has this slightly strong nature, which could have been watered down a bit. Otherwise, it is better than before. That's the penalties, and they've been compared by my colleague on your screen. There you see on the bottom left-hand side. Rishabh, could you make that a little bigger for me?
Yes.
Thank you so much. Punishable with a fine of 1 lakh rupees, which may extend to 10 lakh rupees for second or subsequent offences. So look at that. That is rather heavy on the pocket. And you see, you have to appreciate, it looks very necessary to prevent them from doing something wrong. But sometimes it's really unintentional. I'll give you another example. You have an industrial dispute involving a whole trade union. and they have a charter of demands of 50 demands. Nothing to do with a particular employee. That particular employee steals something. You fire him. You have an inquiry, disciplinary proceedings, and you decide, okay, he fits the bill. He has stolen this thing. We have proved it. Now we discharge him. But you didn't make an application. You didn't apply to the tribunal that was deciding that charter of demands case involving 50 demands relating to 1,000 employees, and this guy happens to be one of them. Therefore, you violated the law. Should you be paying 1 lakh? Should you be going to jail? These are things that need to be left to the wisdom and discretion of a court. And I fear that, imposing minimum thresholds may be perfectly acceptable for a big organization like the traded companies on our stock exchange who are doing so well today, but not necessarily for smaller employers. And that will cause problems. So I think we should jump there. These are more changes. These are more noticeable provisions. You'll find some comparatives on the net. If you apply to us, we might be able to share some of this presentation if my colleague who has copyright over it is willing to license it out to you. But you will see that there are interesting changes. And here is Section 89, which I think is very important because it allows for compounding, which wasn't there earlier. And there's a minimum level of compounding where you're not conceding to having committed the offense, but you pay the compounding fee and say, thank you very much, namaskar, goodbye, and that's it. So I think before you throw me out, I should also say namaskar and goodbye, and thank you for listening.
Thank you so much, sir. Thank you so much. If you have time, can we take 2-3 questions?
Yes, I hope I can answer them because of my disclaimer at the beginning, whereby I have only read this act, but I've never litigated it yet because it's not applicable law. So you can go ahead with the questions, but I might just answer you and say
if it's okay with you,
this has to pan itself out.
Go back to the wages definition slide. Can you go back to the wages?
That is something I know quite a bit about because we've already been asked to advise on that. So I'm happy to explain it to you in some detail. Just a second. Yes, here it is.
No, the next one. The next one.
Away.
The next one.
Well, this is, yeah.
Yes. So I'm putting it on full screen. So this is a question which a lot of people in the legal fraternity and even consultants are mulling upon. इसमें sir यहाँ पे word लिखा है remuneration. So I'll just read this. It says that for calculating the wages under the code, if the payment made by the employee to employer under clause A to I exceeds 1/2 of all the remuneration calculated under the relevant clause, the amount which exceeds such 1/2 shall be deemed as remuneration. So, अब अगर सर इसका ये मीनिंग निकाले हम लोग that the total remuneration उसका 50% से ज्यादा हम लोग allowances नहीं रख सकते हैं. One easy definition is that you keep 50% basic and 50% whatever other allowances. The other alternative is you keep the overall 100 and then you keep 66 basic so that the 50% of basic does not exceed allowances, that is 33 allowances. So which of these two is a correct option for us?
I'm sorry, I didn't hear the last sentence. One second. Yeah, sure. You'll have to start again.
Okay.
The last sentence of your question.
So I'm saying that one easy definition is that आपकी अगर 100 रुपए टोटल आपको पैसा देना है, 100 रुपए देना है, तो आप उसमें से 50 रुपीज यू गो कीप एज बेसिक एंड से 50 रुपीज एज अलाउंस. एक और जो लोग
from A to I.
HRA, whatever, HRA, conveyance, etc. The other definition people are thinking is कि if आपको 100 रुपए टोटल देने हैं, you can give 66 as basic, so that the allowances part, which becomes 33, is 50% of the basic component. So which of them, these two is correct one?
I think the first one.
Okay.
I think the first one. I mean, I think I'll read it to you why. Provided that for calculating the wage, if any payment made by the employer to the employee under subclauses A to I exceeds
Right.
one half of all remuneration, not of the basic remuneration.
Yes.
That's the
Okay.
language of the clause.
Okay. Okay.
Because
Okay.
it uses the word all remuneration and it doesn't make a distinction of the word basic. Therefore, 100 रुपीस में से आपका 50 रुपया ए टू आई में जा सकता है और कहीं नहीं.
Then there is a word written, sir. Then it shall be deemed as remuneration. Otherwise, it should have written of all the wages. Then it should have been deemed as wages.
I think it's a little clumsy drafting, but yeah, it is clumsy drafting. But what he's trying to say is that किसी ना किसी तरह से अगर आप इसको वायलेट करते हो, you don't go to jail, but the employee has a provision to seek an additional payment or a top up which satisfies the clause above.
Okay. 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 I
And
guess
shall
that
accordingly
clears
be
that.
added in wages under this clause. And shall. Then you will go to the penal provisions. Those employees or that employee will complain to the tribunal and say, Dekho ji, A to I has become 55 rupees. Now, if you want us to be fair and to impose the clause, give a direction to this employer to give us 5 rupees more.
Got
So
it.
that it
Got
becomes
50%.
at least now
minimum
you
50%.
asked me a question I could answer. That was quite easy because I've been asked this already.
Okay. Well, I'm asking one more easy question from the audience. So,
Yes, go ahead.
since you know that these these labor laws fall in the concurrent list, so he's asking: is this implemented post circulation of the state rules? What would be the course of action of companies under the appropriate government of the state?
I'm sorry, I heard you, but I didn't quite understand you. Can you
So,
just
will we have? You said that the code might implement from April, but will we
Yes.
have to wait for the states to formulate their own rules before implementation because these laws fall under the concurrent list?
No. What the government is going to do, this is what I've heard, is that they're formulating the rules that go with these codes. And the states are allowed to make state level amendments. Like you saw in the Industrial Disputes Act, each state can make its own amendments if need be. So
Okay.
you'll have a central statute which is forming the bedrock, the base, and the other states will effectively choose if they want to alter anything. But they have to
Okay.
have positive legislation to make a state amendment.
Okay. Okay.
And that
And
requires the
yes,
assent
yes.
of the governor mostly. So it still is effective only after that. And I mean, if you see the Industrial Disputes Act, there are local amendments. Those are minor things. But I don't think the main scheme of the act will be disturbed.
Okay.
And
How much power
I mean, let's
does?
ask one question, Rishabh, if I may.
Yes,
The
sir. Yes,
biggest
sir.
question.
Yes, sir.
In the jump from 100 to 300, can you expect the state of, say, Kerala or Assam or something to suddenly say, no, we don't want it. We're going to go back to 100. That would be quite worrisome. If you had a government in a state which said, no, we want the old provision and we're not going to swallow this pill because our workers, somewhat more left-leaning workers, now I won't name a state, neither of the two states I named,
Right.
where we have a demand for things to be easier and more regulated. And in the rest of the country, you have it differently. So, as I said, I mean, we have to see how this pans out. I'm concerned about that because there is some sting in this law, which is quite quite significant.
Okay. Sir, on continuing the same point, right now the situation is, for example, state like Rajasthan, they have anyways increased the limit from 100 to 300 in for various clauses. How much power the state government have? For example, the current limit is 300. Can they actually reduce it to 100, or they can increase it to 500? Do they have this power?
So I think they do. They have this power, but increasing it to 300 and deregulating is easier than regulating and going the other way. And what I suspect and I fear is that it becomes an election issue. It should not move into the, political landscape to be picked up and drummed about as an election issue. Either we live with this concept of, deregulation and opening up and not having the government inspectors come in with their, pens sharpened and saying, we'll fix you, or and across the country. Because I think the states also will probably accept it because they won't be able to compete with each other for business. And I think for that reason, you probably won't have a political fallout.
Okay, and I guess even commercially, it does not make sense that you reduce the limit because it makes your industries not viable and more companies will switch to other states, I guess.
Yes, indeed.
I'll just take the last question again, not so technical question because our audience is predominantly consisting of HRs. So, question is why you mentioned that there is a concept of temporary worker. So, what is the legal definition of this temporary worker, and if it is as per law, then why we have to make a worker permanent at all?
It's a good question. Very good question. There is no definition of a temporary worker, as far as I know. Somebody can correct me if I'm wrong, but the use of the language in the unfair, what is it called, labor practices, badlis, temporary workers, etc. That's a matter of decisions of the courts. And there have been cases where they have directed regularization of workmen who have been kept on temporarily for very long periods of time. My use of that language was a little loose in the sense that I was talking about a fixed term contract worker even being treated as temporary. And temporary in the sense that what I saw in those cases that I'd read, they were using 45 days and renewal on the 46th day, new contract. And when you talk about it being continued for 32 years, you stand up and say, sounds a bit odd, doesn't it? But on the other side, that's the law of our country. And I have been in a place where I found a forest worker in UP telling me he'd worked for 47 years, but abhi tak permanent nahi kiya. By whom? The UP government. So if that could happen to him, this was some 10, 15 years ago. If this could happen to him under the Industrial Disputes Act as it exists, then it's happening all over the country. And it's happening at the government levels. It's happening to wo temporary hai ji, usko temporary rakha hua hai. Now, if you use that kind of language and you don't regularize these people as a matter of state policy, then you might as well protect them more in that position. And I think, if I'm not wrong, the word gig workers is coming in.
Right, it is. Yes.
It's in the Social Security Code. Yes.
Yes.
I don't know exactly how that will pan out yet. You can ask me a year from now, and I'll give you more detail. But the word gig worker is an interesting one. My understanding of it is it covers a temporary employee.
Okay.
Because what is a gig worker otherwise? What is a gig worker?
I'll ask, what
I'm
is a temporary
I'm
worker
asking you,
otherwise?
Rishabh.
Temporary
You
worker
have a
is like
fair
as
knowledge
good as
of.
permanent.
It's a person who performs work or participates in a work arrangement and earns from such activities outside of traditional employer-employee relations, right?
Right.
So what is a traditional employer-employee relationship? One employer-employee relationship is permanent. Second
Hmm.
is now recognized fixed-term employee.
Hmm.
But this new animal called gig worker is now
Hmm.
recognized by the Code on Social Security. And we're now beginning to give them some rights, which is a good thing.
Right.
Is a temporary worker working for the Uttar Pradesh Forest Department for 47 years a gig worker? I think these decisions will take a little while to pan out. And I don't know the answer exactly right now.
Okay. Okay, sir. And I have to compliment. I have taken a lot of webinars, but the way with the enthusiasm you explain all these things, it's commendable and मतलब सही में सुनने में बहुत मजा आया सर. It's amazing.
Thank you.
The
Thank
depth
you
you
so
have
much.
gone to, and even your team has worked really hard on presentation. Thank you so much, sir. Thank you
Indeed.
so much.
Thank
It
you.
was a
And also
pleasure
thank
having
you
you, sir.
to my colleague Pratik Sharma for having done so much work. And thank you for hosting us on this interesting platform. I think you're doing a great service
Thank you
to
so much.
disseminate information like this.
Thank you so much, sir. It was a pleasure having you. Thank you so much for joining. Thank you so much.
Thank you. Have a nice evening. Bye.
Yes, sir. तो दोस्तों, उम्मीद करता हूं आपको ये वेबिनार पसंद आया होगा. काफी थोड़ा मतलब आप इसको समझ सकते हो, थोड़ा टेक्निकल है, लेकिन ये है टेक्निकल. अब इससे ज्यादा इसको सिंप्लीफाई किया ही नहीं जा सकता. सर ने बहुत कोशिश करी एंड आई होप यू ऑल लाइक्ड इट. कोई भी क्वेश्चन होंगे या कुछ होगा तो अपन ग्रुप पे शेयर करेंगे एंड आई इवन ट्राई कि हमको प्रेजेंटेशन, बिकॉज वी हैव टू हरी अ बिट इन द लेटर स्टेज ऑफ द वेबिनार, तो उसमें हमको थोड़ा सा फास्ट मिले. एंड जो ये वेबिनार लास्ट में देख रहे हैं उनको मैं बोलना चाहता हूँ कि वी टेक बहुत सारा हमको टाइम, एनर्जी, एफर्ट लगता है टू शेड्यूल ऑल दीज वेबिनार्स एंड गेट दो स्पीकर्स. वो लोग आपने देखा कितनी सारी एफर्ट डाल के प्रेजेंटेशंस वगैरह तैयार कर रहे हैं. तो इट्स योर रिस्पॉन्सिबिलिटी कि यू गेट मैक्सिमम बेनिफिट आउट ऑफ इट. एंड कोशिश करिए इसको लाइव अटेंड करिए. बाद में तो आप देख ही लेते हैं, आई नो, बट लाइव अटेंड करिए तो आपके जो क्वेश्चंस है, जैसे आज काफी सारे ऑडियंस के क्वेश्चन में ले पाया, वो क्वेश्चंस हम लोग लाइव हमारे एक्सपर्ट के साथ पूछ सकें. तो चलिए मिलते हैं 19th वेबिनार में. तब तक के लिए बाय बाय, टेक केयर, जय हिंद.